Hi, everybody. Today's How to Read Legalese presentation is on healthcare directives and living wills. It's sometimes also referred to, instead of hearing the term healthcare directive, sometimes you hear the term healthcare proxy, or you hear advanced directives or advanced medical directives, but they're all covering the same topic. So here in Connecticut, we simply call them healthcare directives. And again, maybe sometimes singling out the living will as a separate component. So the purpose of the presentation today is just to briefly go over, again, how to read those documents. But just before we dive too deep into the terminology and specific provisions, the general purpose of a healthcare directive is to appoint a healthcare representative. So someone who's going to be able to make medical decisions for you if you become incapacitated, you're unable to do so for yourself. And the living will is also instructions for withholding of certain medical treatment at end of life. But we'll get into a little bit more detail on that as we get through the presentation here today. So at least initially, what are the key terms? So the person who is signing the healthcare directive, it can be known as the principal or as the declarant, but it's the person who is signing the healthcare directive. If I'm signing off on it, saying I appoint John Smith as my healthcare representative, I am the principal, I am the declarant. And then the term that I've already used now a couple of times is a healthcare representative. So that is the person that you're actually appointing to be able to make those types of medical decisions for you, can stand in your shoes and make those decisions on your behalf if you become incapacitated. Also, we have to be aware of the terms jointly and severally. So if you watched my video about how to read powers of attorney, you'll notice that these same terms may also appear in a power of attorney document, but can appear in the healthcare directive too. And again, these terms only are going to come up if you're appointing more than one person to serve as your healthcare representative at a time. So it's not that you're appointing people in succession. So I appoint my spouse first, I appoint my son as an alternate if my spouse can't do it. That's not what we're talking about here. We're talking about if you said, I appoint my two kids together to serve as my healthcare representative, for example. So in that case, when you're appointing two people, or actually I should say more than one person, because it can be more than two. But when you're appointing multiple people to serve together as your healthcare agents, you have to describe how you want them to serve or choose how you want them to serve. And the first can be that you want them to serve jointly. So you want to handcuff those healthcare representatives together and say that they have to agree on all decisions. They both have to sign off on all decisions. Or the alternative is to say that you want them to serve severally, which means that both of them will have the authority to act. So both can legally make decisions for you, but they can act independently. And a lot of times I would find that people like that severally option if it's a situation where you really implicitly trust both people you're appointing, but maybe one person's out of state or one person's just closer by and more likely going to be able to be there quicker. And then in case of an emergency, sometimes appointing folks to serve severally works a little bit better in those cases because you get a little bit more flexibility. Key provisions in the healthcare directive document. Number one is clearly it's going to be that appointment of both your primary healthcare representative and likely also the successor. So as I mentioned in kind of my initial example, so I appoint my spouse as my primary agent or healthcare representative, and I appoint my son as my alternate. Having an alternate in place is really recommended just because you never know what's going to happen. So if your primary choice to serve isn't able to serve any longer, you still have a backup in place. So be on the lookout for who the appointment of that primary agent is and that successor agent. And there may not be an appointment of a successor healthcare representative, but again, it's highly recommended. So a lot of times there will be. There may also be instructions for what we call anatomical gifting. So if you say you're okay with your organs being donated after you pass, you may want to include specific or may have included specific instructions in your healthcare directive to say, yes, I specifically authorize this. A lot of times with those provisions, you can also specify if you only want and I put in quotes here, organs or parts. And I know that sounds somewhat morbid, but that's a language that's provided to us by the legislature under the Connecticut statutes. So you can say if you want certain organs or parts only to be used for specific purposes. So for example, I have some clients who specify that yes, they do want their organs to be donated, but only for transplantation purposes, not to be used as, for science or to be, practiced on it by med school students, for example. They simply are just looking for those organs to be donated for that one purpose, transplantation. So that language might be in there as well. Your healthcare directive might also have a HIPAA release. And HIPAA is the group of federal laws that essentially state that your doctors or your medical providers aren't allowed to release your medical information to anybody unless you specifically authorize them to be able to do so. So a lot of times, coupled together with the healthcare directive and the appointment of that healthcare representative, a lot of times is a HIPAA release, just to be explicit and state that the person that you've appointed or the people that you've appointed as your healthcare representatives, you also provide a HIPAA release, so they're going to be allowed to speak directly with your medical providers. Lastly is the living will, and this is also another really common provision and may be included again in that healthcare directive document, or it may be a separate document. But the purpose of the living will is to state that you do not want certain types of medical procedures if you're really at end of life. And I've actually, so the language that I've copied in the bottom of this slide here, I know it's a lot, but this is word for word the language that the legislature has given us to use as at least as a starting point for what we might call a standard living will. And to sum up, again, it states that if you meet one of two legal conditions, legal triggers, so you have to be either terminally ill or permanently unconscious. So before I said end of life, so again, it's those are the technical legal triggers, but we're really talking about end of life situations here before the doctors will even be looking at this living will. But if you do meet either one of those two conditions, then you state that you do not want artificial means of respiration, so no ventilators. You do not want artificial means of hydration or nutrition, so no feeding tubes, for example. And you also do not want cardiopulmonary resuscitation, so no CPR. So you puts the doctors on notice that, again, if you're end of life, you do not want those certain types of medical treatments. Also note the last sentence there. It says, I do not intend the direct taking of my life, only that my dying not be unreasonably prolonged. And some of the living wills we craft, we also say, I do specifically want pain medication, so I still want to be kept comfortable. All of those are very common provisions in the living will. So when you're reading through your healthcare directive and living will, that's the language that you're going to want to be on the lookout for. If you have additional questions, again, if you have more detailed questions about what exactly, again, the healthcare directive does or the living will does, we do have other YouTube videos on that topic. So please feel free to check out our YouTube channel for that. And also too, please feel free to check out our website for our contact information. Reach out to us directly, again, if you have some more specific questions regarding your situation.